Welcome everybody to the ninth, is that right? The ninth Stephen Bennett Memorial Program on cutting edge issues in commercial arbitration. There's nothing that we look forward to so much every year as we look forward to working with Jeff Zano and the American Arbitration Association on this terrific program. To be able to invite the 124 people who are online, as well as the special people who are here eating the excellent, I think, non-parade pretzels and fruit that are offered here in the event center at New York Law School. My name is Peter Phillips, and I run the ADR program here. My only job is to welcome everybody, especially to welcome our speakers and our very good friend, Jeff Zano. This will be our last program for our CLE series this year, and we look forward to seeing everybody again in September. Jeff, welcome back.
Second. Okay. Okay, thank you, Peter. And thank you to our audience. I see we have a really big virtual audience, which is terrific. We had 378 people sign up for this program today, and I attribute that to our great panel. And I want to, again, thank Peter, thank the Dean of the Law School, New York Law School, obviously, and Rose for all that they do to make this possible every year. And like Peter said, this is our 9th year. I can't believe it. Next year's our 10th year. Same year as the centennial of the American Arbitration Association, so we're excited about that. This is the Stephen C. Bennett Annual Program, Cutting Edge Issues in Commercial Arbitration. And like I said, we have over 378 people registered. We'll probably have around 250 people at the program today. Before we get to the program, since the passing of our friend in December of 2019, Stephen Bennett, who was an original member of our cast, we named the program after him in 2020. He was on the panel for 3 years. We always do a brief tribute and a moment of silence for him. He was a wonderful friend of all of us in the community. Jen Lupo, one of our panelists, has agreed to say a few words to honor Steve, and then we'll do a moment of silence. So, Jen?
Thanks, Jeff. Am I on? Can you hear me? Great. So, Steve Bennett was beyond real. He was a kind, generous, funny, warm man. And he was a comic. And a lot of people didn't know that about him. And he had a whole pseudo, life with a different name and all of those good things. And I had the pleasure of having him be my co-chair for a couple of committees for the State Bar Dispute Resolution section. I also had an opportunity to look into his life as a comic. And from looking into his life as a comic, he invited me into his life as a friend. He was my friend. He was my mentor. His death got me on a plane to come back from when I was living in Switzerland. I will be forever, ever thankful to him for the things that he did for me professionally and personally. And I wish you could have all met him. And may his memory be a blessing.
Thank you, Jen. And if we can do, that was beautiful. Thank you so much. Steve was a great guy, and I miss him a lot. So if we can do a moment of silence. Okay. Thank you. Okay, so I ask this every year. Who was a member of the original cast years ago? Okay, three? We got 3 people? Okay, cool. Oh, God, you guys are doing your program. The big 3. Okay. So we have 7 panelists tonight that will discuss 3 cutting edge issues. And they are all AAA ICDR arbitrators. We're proud of that. And they're friends. And starting to my right, we have Richard Mattiaccio, charter arbitrator. I'm not going to give their bios. You can look them up. They're all very well known. Okay. Richard Silberberg of Silberberg Dispute Resolution. Steve Skolnick of Thomson Reuters. What they're going to discuss tonight is when are an arbitral tribunal's decisions due? When do they constitute awards? Can arbitral discussions or decisions, excuse me, be modified? And if so, when? That's their topic. Then we have Dana McGrath of McGrath Arbitration, Jennifer Lupo, Jen Lupo of Lupo Law, Arbitration and Mediation. They are going to discuss arbitration and mediation, a greener and more efficient process. And then finally, we have David Singer of Singer ADR Neutral Services and Leslie Burkhoff of Mert Hawk. They are going to discuss ethical implications of use of AI in arbitration. So we have three really excellent topics tonight. And we're going to hold off for questions until the end because they have a lot to cover. Okay, so I will turn now to the first group consisting of Rich, and Steve.
Thank you, Jeff. So Jeff mentioned that this is the 9th annual program, and this is the first of those 9 programs where we've assigned homework. And I think if you checked your inbox at about 2 o'clock this afternoon, we sent around a scenario that we're going to work from, but bearing in mind that it's unlikely that many of you had the opportunity to actually read the scenario, I am going to read it quickly because we want to preserve as much time as we have. The key in my reading it is not so much to take away the substance, but to make note of the dates, because we're going to be talking about the significance of these dates. An arbitrator is appointed to serve on a high-value arbitration involving complicated factual and legal issues. The arbitration is governed by the AAA commercial arbitration rules. Claimant asserts 2 claims. Respondent asserts 1 counterclaim. At the preliminary hearing, respondent objects to the arbitrator's jurisdiction over one of claimant's 2 claims. The arbitrator directs briefing of the arbitrability issue. The arbitrator then issues a written decision dismissing the challenged claim on the ground that it is not arbitrable. The arbitrator then conducts an in-person evidentiary hearing over the course of 5 consecutive days. At the end of the hearing on February 1, so that's your first marker here, on February 1, the arbitrator issues a post-hearing scheduling order providing that the parties should submit post-hearing briefs by March 1, 30 days later. The post-hearing scheduling order acknowledges that both parties, only Neil Eisenman,
It's usually not the speaker that has the phone buzzing.
bad form. Actually, the post-hearing scheduling order acknowledges that both parties seek an award of attorney's fees pursuant to a provision in the agreement authorizing the arbitrator to award such fees to the prevailing party. The arbitrator informs the parties that their attorney's fees requests will be addressed after the arbitrator has determined which party prevailed in the arbitration. After reviewing the briefs, the arbitrator schedules oral argument for April 1, 30 days after the submission of the March 1 briefs. On April 30, the arbitrator issues a written decision that grants relief to the claimant on its surviving claim and to respondent on its counterclaim. The arbitrator requests a submission of briefing by May 15 relating to whether either of the parties is the prevailing party, and if so, which one. On May 30, the arbitrator issues a written decision finding that the respondent is the prevailing party and authorizing respondent to submit a fee application by June 15, to which claimant may reply by June 30. At the request of the arbitrator, the AAA closes the hearing on July 1. 2 weeks later, the arbitrator issues a written decision awarding attorney's fees to respondent. Then, 2 weeks after that, the AAA transmits to the parties the arbitrator's final award, incorporating her findings on liability, damages, and fees. Claimant is very unhappy. Claimant contends that in addition to making mathematical mistakes in calculating respondent's alleged damages, the arbitrator made a transposition mistake in stating the date of the termination of the party's underlying agreement, which resulted in an unwarranted expansion of respondent's damages. Claimant applies for a modification of the final award on August 20. So for those of you who are keeping track, that's an application for modification on August 20 with regard to a ruling that was made on April 30. Okay, so I'm going to turn to my colleagues on my left and my right, The package that we sent out at 2 o'clock contains the applicable rules. And we're going to talk about two issues. One is, what do you call these various decisions made during the course of a case? You call them an award, a decision, a determination, a partial final award, an interim award. What should they be referred to? And what is the significance if you don't refer to them in any particular way? What language should you include in your actual decision to make sure that the party's rights with regard to that decision are preserved? So my first question is, in making her decision that one of claimant's claims is not arbitrable, should the arbitrator consider whether claimant should be able to appeal the decision in court while the arbitration on the remaining claims continues? And if so, why?
I'll get started. Is it working? Yeah. So this one is easier than the others, I think, because you are deciding you don't have jurisdiction, and therefore that's an award. And I would call it an award on jurisdiction, which is very commonly done in the international sphere. But that's really what it is. As far as you call it an appeal, I guess it's vacatures you're asking for. You're never going to get that. The courts are saying that you submitted the issue of jurisdiction to the arbitrator. That's final. We don't second guess that. There's a case from the Second Circuit called Beijing Shogun versus Mongolia that decided exactly that, which is contrary to first options. But first options lives on in kind of a spirit world, but not in the real world anymore. So, but I think what's more important for the claimant here is that they can go to the court that otherwise would have jurisdiction, but for the arbitration agreement, and pursue their claim. And that's what they should do.
Richard?
I agree with all of that. I think there's a fundamental point that this whole problem points to, which is that these decisions, whenever there's a written decision, the arbitrators have an opportunity to characterize what that decision is. And in this problem, the decisions, except for the final award at the very end, are not characterized as awards or orders or whatever. And that's a missed opportunity in practice. The fact that arbitrators may call it an award or an order is not fully determinative of what it is. What it actually does will determine that. But certainly when an arbitrator or tribunal characterizes what it's doing as an award or an order, it's signaling that this is what it thinks it's doing. And that's often influential. So every time a tribunal issues a decision, a written decision, it doesn't say what it is, you're running the risk that it's going to be characterized by a court in a way that the arbitrators don't necessarily anticipate. So they should be called what they are or what they're intended to be. And the appropriate language included in the award. Every time we see in this problem a written decision, there's a risk factor that might be mischaracterized because it hasn't been characterized. But with respect to what Steve says, I agree, and I think yes, arbitrators should consider whether or not it should be subject to review and confirmation or vacatur at the time. And in this case, I would think fairness as well as efficiency would indicate that it should be a partial final award, so that the parties that have been knocked out of arbitration can proceed with some certainty, either by accepting it or by challenging it with the pursuit of their claims in court. They shouldn't have to wait for the entire arbitration to unfold until the end before they could begin their separate claims in court.
Let me pick up on that. So let's assume it was not arbitrability that was the subject of this particular dispute, but it was a cause of action that one side said to the arbitrator should be dismissible at the outset of the case on the law. And the arbitrator is convinced under Rule 34 that the motion can be made because the arbitrator thinks it's more likely than not that the motion will succeed and that it would narrow the issues in the case. So let me pose this question to you, Steve.
Yeah.
If the arbitrator is about to dismiss that claim, should the arbitrator discuss with the parties whether an award should be entered that makes it clear that that's the final determination of the arbitrator with regard to that claim?
So if you asked me this a couple of years ago, I would have had a different answer. I think as an academic matter, if you're deciding that this cause of action is not viable, that's a final decision. And as an academic matter, I think it should be an award. But I've learned from some other arbitrators that what you might be doing when you do that is forcing the party who's unhappy with it to run to court within 90 days to challenge it. And why should you have parallel litigation and arbitration that's inefficient? And so in that case, a very smart arbitrator who I'm still sitting with asked the parties what they wanted. And they said, no, we don't want this to be an award. And we called it a procedural order. And whether at the end of the day, they can challenge, their 90 days has run out on that procedural order because it in effect really is an award. It walks like an award and it quacks like an award and all that because it decided a threshold issue. So I'm still struggling with it, but I think the idea of helping the parties, not force them to do parallel litigation, is a useful discussion to have.
Thanks, Steve. Rich?
I think it depends on why the parties, well, generally speaking, arbitrators don't dismiss claims unless at least one party is asking for that. So you need to probe, I think, what's motivating the party that's asking it, and also have this discussion as to whether or not this will be, the parties want it to be final. And I think you should go with what the parties, particularly if there's a consensus that it can wait, then it should wait. But I don't think it should be left if the parties agree that it is not a final award, partial final award, or even an interim award, then they should stipulate to that. And I don't think then there will be any question in court later. Parties agreed to their process, and I think courts would not look beyond that.
What I'm hearing from both of you is that the arbitrator should try to manage the parties' expectations and fulfill their expectations. And I think this is a sometime overlooked aspect of doing that. What we don't want is for parties to be surprised about the consequences of an award being entered early in the case on a particular claim or less than all of the claims. If a party is not cognizant of the consequences of an award being entered at that time, to anticipate that problem, an arbitrator, I think, should, as Steve indicated, inquire of the parties. You can announce what your decision is. The cause of action is going to be dismissed, but say, do you want me to memorialize this in an award? And do you want me to say in that award that this is a final determination with regard to this claim?
It's all easy, and it was easy in that case that I talked about because everyone agreed. But very often in arbitration, what the claimant wants is the respondent wants the opposite. So if one wants an award and one wants an interim decision, you're going to have to make that decision.
And that's why we're paid to sit there and make decisions. But at least we know that there are factors that each side brings to the fore about why it's appropriate to either enter it as an award or not. And you have that as a baseline for being able to make that judgment.
So one case I had, there was, sorry, just go ahead.
I'm just, let me play the devil's advocate for a moment. Leaving it not as a partial final award is an invitation to the parties to relitigate the issue later in the case. So if they're really discrete issues and you don't think the facts are going to be interrelated, I think, for example, if you have a very complicated contract dispute, but there was a promissory note and a guarantee, and one side wants a partial final award on those two instruments, each of which says they're not subject to defenses. Should you deny it because the other side doesn't want a final award? I mean, it really depends on how distinct the claims are from the claims that remain, I believe. And if the 90 days are going to run, then they run.
I think one of the takeaways here, and I think all three of us agree about this, is that it's not really critical what you call it. It's more important what you say about it in the context of the document. So if you call something an order or a determination or a decision, and don't entitle it an award, but you nevertheless say in the context of what you've written that this is intended to be my final determination with regard to this particular claim or cause of action, then that's going to be the factor that's going to be interpreted by the court as to whether or not a timely application has been made. Would you agree, Steve?
Agree completely, but if you should be consistent. So if you're saying it's final, you should probably call it an award. You don't want people quibbling over words.
Okay. So I went through this scenario and there were a lot of dates in it. And it's not really that unusual a scenario. I actually took this from one of my recent cases. What, if anything, struck you, Richard, as potentially problematic in terms of what the arbitrator did or did not do on this timeline?
Well, the basic problem with this particular scenario is, as I said before, I think the various written decisions don't say what they are. So not having the luxury of actually reading the decision to see what it does, it's hard to say how it would be interpreted. But if it's ultimately interpreted to have that the first written decision on jurisdiction doesn't call itself an award, but was an award, then and by the time the arbitrator gets to the final award that calls itself a final award, you're many, many months past the deadline to have challenged that first award, something that in retrospect is considered to be an award. So I think the basic problem is, I mean, I can't get into what the award actually says or the decision say because we don't have that here. But if the intention is to keep the time to challenge the award or confirm it from running, it's important to use very clear language about that, and that includes not calling it award, but it includes leaving out some information, some of the standard language you would see in an award. So I don't know how well I'm sure in this case the arbitrator did very well in terms of the actual text of each decision, but based on what we have here, there's a risk that something would be characterized as a partial final award that the arbitrator didn't intend to be a partial final, and the parties didn't understand to be a partial final award.
Okay. Thank you, Richard. Steve, what's your perspective?
Yeah, so normally I would say this arbitrator dragged out this case by 3 months and he didn't need to. He could have had the fee application come in with the post-hearing submissions, and then on April 30th, he would have done one final award on everything, including costs. The wrinkle here, and you made this hypothetical more difficult, is that the arbitrator is giving 100% relief to the claimant on its claim and 100% relief to the respondent on its claim. You don't know at that point who the prevailing party is. You may need further briefing on that once they know what the result is. So in this case, I might have done what the arbitrator did based on what he was about to do in terms of deciding the merits.
All right. Now,
If I may, there's also another consideration, which is which you try to get at by talking with the parties about why the application is being made. The parties may very well want a decision that's not challengeable at that point because it may inform their settlement negotiations, which of course you don't want to. If you're the classic arbitrator, you don't want to get involved in. But that's a reason to issue preliminary findings or whatever you call it that is as far away from an award as possible. But that is essentially take the arbitrator's temperature document so that they know which way the arbitrators are leaning. Of course, when you do that, you're opening yourself up as a tribunal to having to hear further argument on these subjects. So it's not terribly efficient unless it does produce a settlement.
let's move to a different topic. With regard to some of the events that are outlined in the scenario, there comes a point when the arbitrator asks the AAA to close the hearings. In this particular circumstance, do you think that the arbitrator acted properly or improperly in closing the hearings when she did? Now, just to refresh your recollection about what the operative facts are, the post-hearing briefs were submitted on March 1. And the arbitrator asked that the proceeding be closed on, let's see here, July 1. Steve?
This is the way it happens all the time. We just got an award out on what's today's Tuesday, yesterday, and there's further proceedings to be had. So there was, the case manager never closed the hearings and won't until the last submission is made. I think others have a different view on that, and the AAA rule talks about the hearing rather than closing the record. And I think that it was written at a time when there really weren't post-hearing submissions. And so I think reasonable people could differ, but I think the arbitrator did exactly the right thing here.
Richard?
Well, I don't see any problem with calling it the closing of the record when the record is closed after everything is in. What I see here as a problem is that along the way, we don't know what the tribunal was thinking in terms of what the deadlines were or should be for those interim decisions. And I mean, I read the rule as the spirit of the rule is that you get your partial final award out, if that's what it is, within 30 days of whenever that record closes, whenever you've had all the submissions that you expect to have and want to have from the parties. And the parties, there's also something that hasn't been said here, which is that the rules contemplate the arbitrators asking the parties if they've had an opportunity to submit everything that they want to submit in the record. That question can be asked at each stage rather than just at the end. When everyone has submitted everything they intend to submit, or want to submit on a particular issue, and you're going to issue a decision as to that issue, I think the better practice is to assume that your decision, unless extended by agreement, parties, is due 30 days from that point. So I see deadlines that are independent of this final closing of the record along the way with each decision on a merits issue, on an important issue anyway.
So back in the day when we all went to law school, I remember the phrase being used by professors, particularly tort professors, a trap for the unwary. And that is what I think is a potential result of not being conversant with the rules and not keeping track of where you are in the proceeding. I would recommend that when you get the post-hearing briefs, the first thing you ought to do when you get the email from the parties providing those briefs is to contact your case manager and to let the case manager know whether you expect there are going to be further proceedings. Here, in this particular case, there was a desire on the part of the arbitrator to have oral argument following the post-hearing proceedings. And the arbitrator should tell the case manager that's what the intention is, so that the case manager doesn't, in the absence of any guidance to the contrary from the arbitrator, run off and close the hearing. Because once the hearing is closed, there are consequences. The final award is due 30 days from the time of the closing of the hearing. So you should be collaborative with your case manager and keep the case manager in the loop at every step with regard to what you want to do. Now, in this particular case, as Steve mentioned, there's a further complicated factor, and that is even after conducting the oral argument and then deciding the merits, the arbitrator didn't know who prevailed and needed briefing on that issue. So it was still inappropriate to close the hearings because otherwise the arbitrator would have had to make a decision within 30 days on every issue, including that issue as to who had prevailed without the necessary briefing. Steve?
Make one comment. I agree with all of that. It's not as dire if you have a miscommunication with the case manager as you made it sound, because hearings can be reopened. So if it was closed in error and both parties are seeking counsel fees and they wanted the case to continue, they certainly would stipulate to reopening the hearing under those circumstances.
Fair enough, but you want to avoid it if you can.
Of course.
Yeah, and I would just add that I think it's useful to have a procedural schedule that contemplates, even if it doesn't set actual dates for post-hearing proceedings, if you think that's the way it's going to go. So it could be, approximately 30 days, approximately 10 days after the filing of the last brief, that, you'll have oral argument, and then set the scheduling later. But obviously, if the schedule contemplates these later states of being in the case, then then I don't think anyone's going to be surprised by a sudden closing of the record.
All right. So what are the consequences, Steve, of the hearing closing on a particular date and the award not forthcoming within 30 days?
Somebody would have to object and say that the award's late and therefore it's no good or whatever. If they just sit on their rights and the award comes 5 days later, no court's going to set it aside on that basis. Would anybody really want to write to the arbitrator on the 30th day and say your award's due? If it's not here by 5 p.m., we consider the arbitration closed? I don't think anybody would do that.
Okay. So you talk to your case manager, also talk to the parties. And it may be that you'll recognize that the case is very complicated and that you as the arbitrator are going to need more time. Don't just assume that you can send it in when you can. You should talk to the parties, or better yet, have the case manager talk to the parties and say, look, the arbitrator is looking at this and it's a very high value case, and there's 8 feet of briefing from the table up, and he needs more time or she needs more time. The case manager can then go to the parties and say that and get an extension. To Steve's point, I don't think a party is likely to object because that party still needs the arbitrator to decide that party's claim. So the teaching point, I think, here is just make sure that everything is in line with what the rules provide, and to do it either by caucusing with the case manager, caucusing with the parties, or both. All right, one last point here. And that, yeah.
Before you move on, I think it's also important to raise these issues as early in the case as possible. If you're confronting a obviously complex case and a rule that says the award is due in 30 days from the close of the hearing, you may want to raise with the parties whether that 30 days, with that 30-day rule, as I recall, goes back to the days when arbitrators were being told not to issue reasoned awards. And when you consider that some amount of time is needed as well for your draft award to be reviewed and so forth, so that 30 days isn't really 30 days. Yeah, it's perfectly appropriate in a complex case, I think, to have that conversation with the parties. Their expectations may be that 30 days is the absolute limit because one of the parties is for sale, and the closing is awaiting the determination of the claims in this case and so forth. I mean, it's important to flush those issues out so you know upfront what you're dealing with in terms of managing your time.
And then you can actually incorporate it in your preliminary procedural order.
Yeah.
All right, so 2 last quick things. Suppose the parties had an agreement, the underlying arbitration agreement provided that the arbitration shall be concluded within 120 days of the date that the arbitrators were appointed. And you as the arbitrator say, oh, that's unreasonably short. What should you do?
You have to take the temperature of the parties, as Richard just said. I had that case. It was a $400 million claim, and it said in the clause expedited procedures. And so I was appointed in April, and I got an award out in September. And we stuck to the procedures because the claimant was in a hurry. Whether they had a good reason to be in a hurry or not, I don't know. But if it's in the agreement, you've got to abide by it. And very often claimants want to stick with it.
Yeah, I've had a different experience. Yeah, it does occasionally happen because there's something hanging out there that really this case needs to be decided. But very often when you sit down at the preliminary hearing and you go over what the parties want to do before they have their evidentiary hearing. You say, okay, let's set the evidentiary hearing so that I have time to get out the award. So now you take 30 some odd days, 40 days off of the schedule for that. And now let's take everything that you both sides want to do to get this case teed up for a hearing and get it done in that time frame. Suddenly the parties realize that they can't live with the deadline that's in the contract and they agree to something else.
Right, but I agree with that. But the point to remember is this is a contract. You can't ignore it.
No.
And if you're going to get the parties on board, or if the parties are more than willing to change it, you might consider, as Arbitrator Khan sitting in the back told me would be appropriate, you should get the actual parties to sign off on an amendment to the contract, not just the council. You know, the parties may be surprised that they're not getting an award, you know, for a couple of months, and then the lawyers come in and say, well, we changed that. You changed what? You changed our contract? So in that case, Sherman and I did ensure that the parties actually, through their authorized representatives, amended the contract to provide for a longer period of time. All right, last point. So suppose this party, this claimant here in the scenario, didn't like the award and was right. You know, the arbitrator made a mistake. What is the significance of the fact that it waited until August 20, after the final award had been issued, rather than seek to modify the original ruling that was made months earlier? And, you know, bonus points, if you remember Commercial Rule 52A, which says within 20 calendar days of the transmittal of any award, any party upon notice to the other parties may request the arbitrator through the AAA interpret the award or correct any clerical, typographical, or computational errors in the award. So I'm focusing on the any award language.
So in this case, according to your scenario, the April 30 merits decision that is being challenged wasn't called an award. And I doubt that any arbitrator or the AAA ICDR would say that ran 30 days after April, 20 days after April 30th, because it did challenge it timely after the award was written, and the award actually incorporated the decision as well and had the same arithmetic mistakes in it, and it's now being challenged.
So I'm going to change the facts on you. Suppose the ruling on the merits was called interim award.
Then it's going to be up to the arbitrator to determine whether it's timely or not. And the courts will defer to the arbitrator as to whether it was timely. The arbitrator is going to interpret the rule, and I think it could be interpreted either way.
Richard?
I agree with all of that. I think, but what this highlights is the need to have clarity on each of these decisions, because if it's ultimately determined that the award that the decision on the merits was the award, then it's untimely. So the arbitrators should take charge of this, not only in the language in the decision itself, so that it doesn't come under some category that they weren't expecting, but call it what you think it is. And if there's clarity, then I don't think you have these problems.
So we circle all the way back to the beginning of our program about making sure that you entitle the award what it is and that you say in the document what you intend it to be. All right, we'll send it back to Jeff.
Thank you. Rich, I said no questions until the end, but a quick question for you. You're on the council of AAA ICDR, and so is Dana. There is efforts right now to define the various terminology for awards. Is that correct? And when do you think that will be accomplished?
Yes, so Dana,
guidelines for arbitrators.
So Dana is on the LCC, Large Complex Case Committee of the Council. I'm on the Arbitrator Committee of the Council. And this is actually a joint effort of both committees. We're actually merging members of each committee into a task force, which is currently studying all of the issues that are actually in this scenario, studying what it is that an award should be called or a ruling should be called. And there's actually a second task force which is studying whether 30 days is still appropriate for a decision following, for a final award following the closing of a hearing. And there is likely to be some guidance coming out, I would say, in the fall, The committees will make their recommendations to the AAA management, and the management will, as they always do, look at it carefully and ask questions and provide feedback. But likely there'll be some kind of decision as to whether to either provide guidance or change the rules sometime in the fall is what I would expect.
Thank you. I look forward to that. Didn't mean to put pressure on you on that one with your committee. Richard, and Steve, thank you so much. That was terrific. Now we're going to turn to Dana, okay, and Jen. They're going to be talking about the arbitration and mediation, a greener and more efficient process. And you need to, today is Earth Day, is that correct? Again.
Yes, so
In-
there's a
it
slide
is.
for this portion, and is this working?
Is.
So this is the light,
sorry.
cheerful part of the program today or this evening.
Happy Earth Day, everyone.
Happy Earth
Happy
Day,
Earth
everyone.
Day.
Being
Oh, yeah.
April
Oh, yeah.
22.
Oh, Dana, 1 second. I have to give the first code. The first code, we have CLE codes. The first code is A for American, A for American. I need 3 letters.
It takes the
And
entire.
This
he's
is the
going to
first one.
tie
This
it
is the
into
first one out of
Earth
3.
Day at some point too, the special code.
Oh, sure. I think you can figure out where we're going with this one.
So as you probably know, today is Earth Day 2025. April 22 is always Earth Day, and each Earth Day, like many annual holidays or events honored around the world, has a theme. So like for International Women's Day, there was a theme. So here we are for Earth Day 2025, and the theme is Our Power, Our Planet. And that's open to interpretation in many different ways. But the theme and the purpose of Earth Day is to encourage individuals to take action through education, advocacy, and community support. And so people ask, how can they help to further the goals of Earth Day and the awareness? And so I asked Jen, how can we help in the context of a program on commercial arbitration? And we put our heads together, and we're going to share with you a lot of things that are done in the commercial arbitration space to make arbitration greener and also more efficient. They seem to go hand in hand. And we're going to talk about it from a couple different perspectives. The counsel, the law firm, the arbitral institution, the arbitrator, the client, a lot of different perspectives. But why would we even care about how we manage documents and data and, the whole greener arbitration turns on digital documents? Why wouldn't we just stay with paper in 2025? I ask you on Earth Day.
So I have an anecdote. When I was an advocate, we did an arbitration in our firm, and it was partners and me, and we had to deliver the bundles. And when we delivered the bundles, the arbitrators' comments were that, we could have delivered them on a pallet. And then the other comment was that the bundles were so large that they could have been intervening parties and they should have been added to the order. So, I want to say that, it's funny. We've had all of these moments in our lives where we go, oh, those are funny things and what have you. But really the purpose of our talk today is to try to encourage all of you to make some incremental changes to the way that you approach the practice of arbitration. So at this point, I am going to turn it back to Dana, and she's going to run through our timeline of how did we get to sustainability as being a portion of arbitration.
So I also have to confess that I carried some very, very heavy bundles into hearing rooms and received less than enthusiasm from the tribunal back in my day. So now as an arbitrator, I really do try to go paperless and to do everything electronically. But that is today, 2025, and Earth Day, no less. But looking back at sort of, how we got to a point where we're really focused on sustainability with respect to how we do arbitrations. It wasn't so long ago where the bundles were really expected. It wasn't, only because there was a pandemic and people sort of pivoted quickly to more electronic communications. It's been incremental over the course of some time. And I would say, really it was in the early 2000s where companies and law firms and clients were starting to focus on, all this paper and the space it takes and, it just, there's a more efficient way to do it. And there was a developing focus on sustainability and, the, the well-being of our planet. I don't want to use any politically charged terms. So companies and clients really cared about developing programs internally that would sort of effectuate or their concerns about trying to do business in a way that was better for our planet. And for a while, it sort of fell within an umbrella of a number of sort of other concerns that companies or shareholders might have about how a company operates. And the term, corporate social responsibility was used, CSR. I would say then it sort of transitioned to be called ESG. So that's environmental, social, and governance. Both CSR and ESG sort of umbrella terms for some of the protocols or practices that companies, law firms, and others put into practice to try to implement the desires of, the leadership or the company, the shareholder. So if the environment is important to the people who care and are making the decisions, they can put into place protocols. But how does a company that's done business in a certain way for how many decades or however long learn how to pivot to do things in a more planet-friendly way? And so they, that departments were developed and protocols were issued, not just by the one that were going to focus on one organization in particular, but leading up to when arbitration focused on being more sustainable. Companies were doing it and they developed policies and a whole ESG department often at companies. And the reasons for doing this were not just the shareholders or the most important people in the room wanted this, but I think that a lot of other people whose voice might not have been as important before was gaining importance as, the workplace became more diverse and you had more diversity of thought and doing things that were, planet friendly and sort of looking towards the future and how our role, impacts the planet and impacts the future for, our people, humans here, that hopefully will have as beautiful a planet as we have now. They decided that incorporating those decision makers into how to sort of implement those policies was a good thing. And it resulted, I think, also as sort of a side aspect in diversifying the people in the workplace, because there was a lack of knowledge of how to do this. New people were brought in. And so it's not only the environment, planet that benefited, but sort of it contributed to a bit of a culture change, I think, at some companies as well. All right, so let's fast forward to the Campaign for Greener Arbitrations. This is an initiative that was launched by Lucy Greenwood, who's based in London, who's been doing international arbitration for decades. She's now a full-time arbitrator and has been for some time. She was in private practice both here and in London, and she saw some really huge cases, huge, room-filled bundles. I mean, enormous amount of documents. And so she's contributed a lot to the arbitration community generally. This is one of many things that she's done to make arbitration better, I think. But launching the Campaign for Greener Arbitrations was sort of groundbreaking for the arbitration community. And its mission is to reduce the environmental footprint of arbitration, of international arbitration, and I think that applies equally to domestic, especially in a country as big as the United States. And so it's called the Green Pledge. And the organization invites individuals, law firms, companies, anyone, stakeholders, arbitral institutions who are, committed to trying to make arbitration more environmentally friendly to take the pledge, to sign the pledge. And the principles of the Green Pledge are to embrace digital practices, reduce travel, reduce or offset emissions, make choices that are more sustainable, better for the sustainability of the planet, and to advocate, to spread the word, to increase awareness about what kinds of practices could be undertaken to be more sustainable within the arbitration community and even beyond. So that was where the CGA, the Campaign for Greener Arbitration, started with the Green Pledge. It now spans the globe, quite frankly. It started in London, and now there are chapters, or we call them subcommittees, around the globe. Jeff Zano is on the North American subcommittee, as am I, and there are committees that work across borders, and it's just an incredible initiative. And you're going to hear bits and pieces of it today, and we'll share the web link where you can find what's most useful for you in your practice after this program.
Thanks, Dana. So, why should this matter? You don't have to be an environmentalist to recognize that you don't want to have a bundle in your house or your office at the end of an arbitration. You also don't have to be an environmentalist to recognize that removing that bundle from your home or your office will cost you time and effort. And that time and effort, because those are confidential documents that have to be removed and dealt with in a specific way. I'll give you an anecdote. During COVID, I was counsel on an arbitration for an architectural malpractice case. And there were bundles. Even though we did as much as we could electronically, we did have to deliver the plans for the construction in IRL. So at the end of the arbitration, we collected the respondents and the claimants. We made a pool of cash and we collected all of the live documents that had been distributed to folks' homes and then paid to have them physically destroyed because we were all remote. And that actually ended up costing an additional $2,800 just to collect those documents and have them destroyed. Now, that may not sound like a lot of money when you're talking about, the claim was in the 7 figures, but it adds up and it makes it something that you really should be considering. So let's talk also about some of the things and some of the reasons why. So law firms started considering the environment and sustainability, because it really was something that was beneficial to the bottom line, right? If you don't print it out, then you don't have to buy as much paper and you don't have to buy as much toner, right? Those are just two easy things to look at. But really right now, what we're talking about is not so much the toner and the paper. What we're talking about is also rethinking the way that we produce our documents in the first instance, and secondarily, how we transmit them. So here are a couple of things that we do, at least I'm doing, and I'm hopeful that you folks will take away. For arbitral for arbitral institutions and hearing venues, these are a couple of things, and AAA does, and as does JAMS, they do a fair amount of these things. So offering digital filing of documents, but as arbitrators, encouraging your parties to utilize, web file at AAA, and case management systems as well. Providing guidance for arbitrators. Look, you don't learn this on your own, right? Some folks come from the analog world and other people come from the digital world. And then there's some people that straddle in between those two different worlds. So nobody's born all knowing. So it would be beneficial if the arbitral institutions would put together programming for their neutrals to understand how to better effectuate these changes to a more paperless arbitration and even mediation hearing. You still get large amounts of paper in mediation as well. Then we would talk about things like the digital facilities, right? Hybrid hearing capabilities, having all of that type of technology available to arbitrators, parties, and making sure that the stakeholders understand what the arbitral institutions have to offer in terms of hearing rooms, those types of things. And then here's a simple one. When you're requesting catering, right? Maybe we get some dishwashers rather than having, single-use plastic for everything. You can get very, very, micro on some of these things. Now for arbitrators, right? Leading by example, right? It's not that complicated. Today, you see that Dana and I are utilizing our tablets. This is my bundle now, right? I know Nadia, you've laughed, but yeah, this is my bundle. And my setup in my office is very tech forward. I've always been tech forward. That is how I have developed my practice as an arbitrator and mediator, but even as counsel, I was always utilizing technology to make my life more efficient, so that when I can best serve my client, or in this case, the stakeholders, the other stakeholders in an arbitration or mediation, by not having to worry about those other things. So simple thing like this. There are plenty for arbitrators also. We have to do a little education of counsel as well. Counsel will still want to send you a bundle. You have to, tell them it's okay to cut the cord from the bundle. And it's also okay if you need a bundle in a case, right? This is not a steadfast rule that you have to be all green at all times. You have to make the decision based upon the case. I could not have seen that architectural malpractice case having been done without having some paper. And there was just no way we were going to be able to do it. Everybody would get up and go look at the plans. We all, even though we were on Zoom, that's how we were doing it. But those are using common sense. Model clauses. So having a model clause that you might want to draft yourself that you can share with the parties about utilization of mostly digital papers, and to use the word papers, to deliver through web file, to set up FTP sites, to not be having all of the paper even in the hearing room for exhibits, having dedicated tablets. These are a couple of things that you can consider doing wherein you don't have to have any paper that is in your hearing. Again, based upon whether or not it works for the hearing. Witnesses, right? Flying somebody in for a half day of testimony from Germany doesn't really make much sense. That is a large carbon footprint to put somebody on an airplane when we now have all this wonderful technology, some of which we had before COVID. We just didn't know how wonderful it was, where we can have that witness testify via either WebEx or Zoom or BlueJeans or any number of video conferencing teams, et cetera. Keep those things in mind. Sometimes parties need a hand to understand the things that are available, and change is very complicated for people. So you have to remember that some people may want to provide a bundle, some people may not, but most people are going to assume that you want a bundle. So you have to take the proactive step as the arbitrator to make that. What you were saying, a bundle of joy. Sometimes it is. Sometimes it is. Then the last thing I will leave you with is that, you know, most law firms, funding organizations, they really want to do the right thing. Sometimes they just need a little bit of a hand. And I'm not any great, and this is going to sound crazy, but I am very conscious of the environment, but I'm not like an environmental zealot. But I do think these are some things that are easy for us to do that can make it a much better situation for us in the hearing rooms, for the stakeholders, and also to do a good thing for the environment. So what are the other, Dana, what are the other ADR initiatives that are out there and best practices? Oh, we have the World Mediator Alliance,
well,
ADR Notable. all that
Yeah,
stuff.
yeah, we can, yeah, we'll
And we
talk
have
about some of
just
those.
about a
I
minute.
know, yeah, we're tight on time. I just wanted to sort of close the loop on the campaign for greener arbitrations, which I think, you know, has the benefit of being both, you know, business-minded for the bottom line of companies as well as protecting the planet. But I did get carried away with my love for the planet today because it's Earth Day. But all of this is actually very good business, as is many of the initiatives that fall under sort of a social or ESG umbrella are. But the campaign for greener arbitrations, if you're not familiar with the website, it has a lot of model protocols. It has a lot of resources. It has guidance. It has, you know, ways that you can facilitate your conversation if you're an arbitrator with the parties, counsel's conversation with the client. And there's a protocol for almost any role you can think of, whether it's an arbitral institution or arbitrator or everything. So you could just go to the website and literally click when you're deciding you know, you can add something to your procedural order number 1, or you know, your client wants to raise something. So I would just say that they're actually very intentionally user-friendly to all of the different stakeholders in arbitration. And then maybe for some of the other initiatives, I'd turn it to you.
So real quick, some of the other, they're comparable for mediation as well. So for mediation, you can go through the World Mediator Alliance. They have a very similar type of initiative to the Green Pledge. The last thing is, so here's a couple of, I got some bullet points. Lead by example in your procedural orders and your award writing. The second is educate your counsel about the green protocols and the Green Pledge, and get buy-in before you add it to a procedural order. Do get buy-in from folks. Utilize the model clauses that are available on the website. Adopt your own personal carbon tracking tool, right? Like you can think of it your own way if this is something that's very important. One of the easiest things is a direct flight. A direct airplane flight utilizes less, it has a smaller carbon footprint than making several changes, several connections. And the last one is join and sign off and take on the pledge.
Thank you, guys. That was terrific. Did you pick that topic because it's Earth Day? You did. Okay, you knew the date. Okay, very cool. Okay, I got to do the next CLE letter. It's B. B as in bar. The first one was A as an American. Second one was B. B as in bar. Okay, so for our final group here, we have David Singer and Leslie Burkhoff. They're going to talk about the ethical implications of use of AI in arbitration. And AAA ICDR kind of likes AI, as you guys probably know. So take
We've
it away.
noticed. We've
guys.
noticed, Jeff. Can everyone hear? Okay. All right. Thank you, Jeff. And we are going to look into these issues about the use of AI and the ethical issues and concerns that they raise. I should mention, as I was reading through some materials yesterday afternoon, there's all sorts of guidelines and rules and codes and so on, and a number of them will be up on the slides for you to look at. And I was thinking to myself, God, I wonder what Chat GPT thinks about this. So I went on Chat GPT and I asked, what ethical issues does AI pose for arbitrators? And in seconds, it spit out a bunch of things. And we're going to share some of that with you as we give our little presentation now. Now, I just want to add that I must say that at the time we started hearing about AI and then been bombarded with it, some time ago, I thought that at my age, I was going to avoid it, that it just wasn't going to happen for me. I was going to comfortably sail on with the rest of my career and not have to deal with anything AI related. And it turns out that I was incorrect, and that it has caught up to me as it's catching up to all of us, or has caught up to all of us. And it's being used, and we as arbitrators are being asked to learn certain AI tools by the AAA, as Jeff has alluded to already, and I'm sure other providers. And so we have to learn this stuff, and we have to become versed in it and come to understand it. And that kind of segues into our first of our 5 broad topics here, which is competence.
That was such a nice layup, wasn't that? We practiced for hours. So yes, it's caught up to us. It will pass us if we don't sort of get on board. And not just in our field of arbitration. Obviously, this applies to everything. But as lawyers, and both that's for advocates and for arbitrators, and you'll see throughout the presentation, some of these rules that we refer to sort of direct one way or the other, but comprehensively, all of these constructs get picked up one way or the other. So we all know as lawyers, it's a duty of competence. We have to provide competent representation to our clients. Well, if you're talking about AI in particular, and you don't know what it is, and you don't know what it means to utilize it, and you don't know how to utilize it, and you need to, you are not competently representing your client. It's as simple as that. And so if you misstep, which we'll talk about a little bit later in areas such as confidentiality, you may be providing ineffective competent counsel to a client and really have a lot of different issues. So it's important to stay informed. AI is changing, AI is learning. That's the whole construct behind AI. It learns, I don't have any mathematical statistics for you other than I know it learns at an exponential rate. But it's super important for us to understand where it is popping up in various modalities throughout the use of throughout the use and implementation within our profession. And you've got to understand the limits. I wrote an article a while ago. I'm probably not the only one. Will robots replace us? Jeff actually asked this on a program we did a couple of hours ago on another webinar. The answer is no, they are not going to replace us. Quite frankly, AI already exists separate and apart from ChatGPT or ClearBrief or anything else. AI is already in existence in every aspect of the legal profession, including arbitration. And there are some protocols on the Amazons and other online retailers that have literally some form of AI dispute resolution that does go on. But you have to understand what it means. There's bias implicit in it because AI is programmed by individuals, and those individuals predominantly are not representative of the entire universe of the world. So there is a slant into who, potentially white males, that are programming information into AI. in some respects. You also have to understand something called hallucinations. And hallucination is basically made up stuff, as simple as that. It is something that is not accurate, does not truly exist, but is derived from the information that AI is generating. And the easiest way to represent that to you is, hey, everybody's heard about the cases where the lawyers have gotten sanctioned because they cited cases that didn't exist. Why in the world nobody would read a case that they are citing? You should read it even if you get it off LexisNexis, Westlaw, whatever it may be. But it wasn't a real case. It didn't exist. That's a problem. That's also not competent representation. And it lacks judgment. AI has no judgment. What we talked about earlier and I've written about is AI can do a lot of things. It can parse information. It can give you statistics. It can organize thoughts in some respect. It can create a timeline. It can give you cases. I would refer to accurate cases. But you are missing both judgment and human emotion. And that is what is always going to, as far as I know, set us apart unless we exceed whatever the Terminator has done or things like that. But that piece is missing. And the reading of expressions and the understanding of body language. But if you don't understand all the positives and the negatives, which quite frankly change, I go back to you're violating, at least in this instance, New York Rule of Professional Conduct 1.1. And why is all of this so important? Let's lead it off to the process.
Okay, thank you. And I should just add that, we've done this before. When COVID hit, we all had to learn how to figure out Zoom and other online platforms. None of us was particularly facile with that or even knew about it necessarily. And we had to learn how to use them and run hearings using them and conduct remote proceedings. And we did. So we're in the process of doing a similar thing now with AI. And as it relates to what Leslie was just saying, we need to really make reasonable inquiry about AI, about the tools with a view to understanding the technology and its function and its data. So then we also have an obligation to maintain fairness and due process. So arbitrators have this obligation, period. And we can't sacrifice it due to or in any way relating to the use of AI. So if arbitrators use AI tools to help draft decisions or to analyze submissions, the output may contain biased language or assumptions or conclusions that are in the material that we're relying on for AI. Relying on biased tools can undermine fairness and can undermine impartiality. So what does ChatGPT have to say about this? It says that AI systems are only as unbiased as the data they are trained on. AI could perpetuate or amplify these biases. So it acknowledges it. Now, as it relates to due process, as you see up on the screen, the Silicon Valley Arbitration and Mediation Center makes the statement that where an AI tool cannot cite sources that can be independently verified, an arbitrator shall not assume that such sources exist or are characterized accurately by the AI tool. And this is something that Leslie has already referenced. We know of, we've all heard of plenty of cases in New York and around the country where counsel have made submissions to courts, and the same could apply to in arbitrations where it's just either false or made up or hallucinated, as they call it, and for some reason, laziness and otherwise, the counsel didn't bother to verify the information or cite check or check quotes or do all the things that one would expect that a counsel to do. And it's something that would apply to arbitrators too, when using AI. And this, of course, has resulted in sanctions and bar suspensions and other consequences for people who have failed to appreciate what they need to do when handling AI. Now, there's also the transparency aspect. And let's see, ChatGPT has said that using AI...
He's proving that he's caught up and he's on top of this because he's chatted all of it.
I'm chatting. I've done a chat, which took all of several seconds, as I mentioned. So it says that using AI-generated analysis, it may be difficult to explain how conclusions were reached. lack of transparency undermines parties' right to understand decisions and potentially to challenge those decisions. So this is sometimes referred to as the black box problem, where information analysis may be generated by AI, and you don't know where it comes from, what it's based upon. And if you don't know that, then of course, as an arbitrator, you can't explain where it comes from or what it's based upon. And if you're using it as a basis to come to your conclusions or your decisions, you can't explain it. And so that's a problem because the counsel and parties have a right to understand how you arrive at your determinations, how you analyze the problems. And if it can't understand it, that's not a good thing. And you can't challenge it because of that as well. So that moves us on to
Maintaining independence. It's almost as if ChatGPT just helped us flow our organizational thoughts, but we did not use it for that. David and I actually did this together. But it's maintaining independence. So if I feed all of my party submissions and my transcript and my expert reports into a version of a ChatGPT type tool, and it turns out this decision, well, I've missed quite a few of my ethical obligations here. And one of them's on the screen, or many of them are on the screen, but I'm not independent. It's not my judgment that's here. I've basically, if you would delegated this out to somebody else, and that somebody is a AI Autobot, or whatever we'd like to call it, that is doing this for me. That's not what the parties expect. That's not what the parties signed up for. They signed us to decide that, although apparently they're disagreeing with me right now. And it highlights. Here we go. I'm gonna have to watch what I take home later. No driverless cars. It's Alexa. I mean, but it hits a bunch of different things. So first of all, there's in the AAA's ICDR guidance, it specifically says that when using AI tools for certain things, legal research or evidence analysis, we still should ensure that our decisions reflect our own independent judgment and reasoning. When we look at just the general New York rules of professional conduct, because remember, those rules are not, they're geared to lawyers as a whole, and arbitrators mostly are lawyers, but they're talking more advocacy. But it also ensures that if someone else is working on this, they're being supervised, okay? And I'm not really supervising an AI amalgamation of information. I'm feeding it in, but I have no idea what they're doing. Different than if I sign something out to a junior associate, comes in, sits, talks to me, we look at the research and we decide what to do. We have another code of ethics by the AAA ABA, which is basically saying I can't delegate. And then there's a second one on guideline 6 that also says I can't delegate any part of my personal mandate, which, by the way, those two rules would be directly in opposite to the one that says at the top, guidance of arbitrators in AI, is that I can use it, but for what purposes can I use it? And I don't think they're, on their face, they look to be opposite, but they're not necessarily oppositional to one another. So for example, no different than a lawyer can use Westlaw or other tools to research, I can go ahead and utilize with limitations that we'll talk about when we get to confidentiality and restrictions, an AI tool to organize data, to maybe give me a timeline, to maybe get the cases organized for me, to put something out. I must independently analyze anything that comes to me. I must look at it. I must check it. It is a tool. To me, it's like any tool in the toolbox that we're allowed to utilize, but it doesn't supplant my independent decision-making. It doesn't supplant all of my obligations as an arbitrator. And if you synthesize all of this, there's a way to incorporate it in your practice, which I will confess I'm learning because I'm being trained on ClearBrief, which is one of the recognized ones, and trying to figure out how to incorporate that concept appropriately at the right time. And so maybe it's to take the bundles and reduce them to an organizational pattern or timeline that I can then go back and check and maybe save myself some hours and save the party some dollars. But at the end of the day, no different than when I'm an advocate, the buck stops with me. I have to touch, I have to read, I have to vet, I have to verify. Then I have a question of what do I then have to disclose? Taking us to David's next slide.
David, before you go, I have to get the last CLE letter. It is association, association, so ABA, American Bar Association, ABA. David, sorry.
I'm shocked, Jeff. I'm shocked.
Didn't think he was
I was
going.
going to do AAA, but I said,
So let's continue with a little ChatGPT about maintaining independence. It says, if an AI tool contributes to a flawed outcome, who is responsible? Blaming the AI tool doesn't absolve an arbitrator of responsibility. Arbitrators must remain accountable for all aspects of their rulings, regardless of AI involvement. And it also says that over-reliance on AI tools can shift decision-making responsibility. Delegating too much reasoning to AI may compromise independent judgment. This could erode the core ethical duty to remain independent and impartial. So now moving to disclosure. The AAA ICDR guidance says that arbitrators should disclose their use of generative AI tools when such use materially impacts the arbitration process or the reasoning underlying their decisions. Now, there may be different interpretations or opinions about what constitutes materially impacts. If there's something that's being done strictly for ministerial purposes, creating a scheduling order, for example, that may be an example, but some arbitrators may feel most comfortable disclosing any use of AI. I mean, that would be a judgment call, I think. And ChatGPT jumps in once again. Parties may not be aware that AI tools are being used. Failing to disclose AI use can raise ethical red flags. Parties should have an opportunity to object to or understand how AI is being used in their case. So this is another example of parties, counsel, in the event parties are using AI, the arbitrators just knowing what is being used, understanding what is being used and how it functions so that they can then accept it or not. I think if a party objects to the arbitrator using AI or using it in certain manners, that the arbitrator should refrain from using it. Then there's the issue of using AI outside the record. And there the consensus is that an arbitrator should not rely on AI generated information outside the record without making appropriate disclosures to the parties beforehand and allowing the parties to comment and object if that's how they feel. And this is kind of similar to the analysis that would be done with regard to research outside the record or research being done outside of the legal analysis and briefing that's being done and submitted to the arbitrator. The consensus, the best practices view is that that should be disclosed if that's done. That would give the counsel an opportunity to be advised and then to comment on it, object to it, or at least brief the law or the case or the claim that the arbitrator may know of outside of the record. Disclosure also comes into play. I'm not going to really get into this in billing. There may be interest on the parties of knowing the billing and whether AI is being used. Should you bill time spent using AI, or should you bill for time that you would have spent but for the use of AI? Well, interesting. I think the right position is that you bill for the time spent, not for the time saved.
I'm pretty
but
sure that's the
Who
right
knows?
answer.
Some people
Ask
may feel
ChatGPT.
differently. I didn't specifically ask ChatGPT about that one. And then finally, as it relates to disclosure, is that the arbitrators regulate the hearing. And the arbitrators do what is necessary to maintain fairness, to maintain the integrity of the arbitration process. And arbitrators may regulate the use of AI similarly to preserve the integrity of the proceedings and the award ultimately. So disclosure of the use of AI tools by counsel may be required to the extent that it may have an impact on the evidence presented, to the extent it may affect the outcome of the arbitration, or otherwise involve a delegation of an express duty towards the arbitrators.
So this allows the not only the arbitrator to know what's going on, but also opposing counsel to understand the manner in which counsel is, the manner and the context in which AI is being used or is to be used, and can enable arbitrator, opposing counsel to comment on it, to object to its use, to object to the admissibility of certain evidence that may be created by or influenced by AI. So those are a whole series of issues that the arbitrator has to deal with in terms of maintaining the integrity of the process.
So our last comment, and I'll bring it home pretty close to on time, although I may need a minute or two, which I alluded to earlier, is confidentiality. Now, we all know as practicing lawyers, things like attorney-client confidentiality, privilege, keeping confidences, keeping our files secure. Jen referred to earlier the need to shred the bundles, if you would. We all have those obligations at the end of the day. So where does this really pop up in AI? Well, if you think about it, if you want information and you want to get a determination on something and you put it out in the ether in ChatGPT, because that's what it is, you're going to disclose facts, potentially. So even if you change the names to protect the innocent, Sally Jones sued Bob Jones and did blah, 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 and whatever it is. But to get data back that's useful and informative, you're putting meat on the bone. The more meat you put on the bone, the more meat is out there in the universe, and it's not controlled. It's an open source system. So if we are supposed to keep the information given to us as arbitrators essentially confidential, we understand that there's not pure confidentiality and there's not the restrictions that everybody necessarily thinks are in place, but generally speaking, that's our obligation. And the parties have signed a confi agreement and we've put something in place. Well, if you feed it out there in the universe, it isn't confidential. It's out there, even if you try and change some of it. So closed source systems which retain the integrity and the anonymity of the information, and you can at least stick to any of the various rules and ethical obligations that are listed on this slide here, are incredibly important, because otherwise you've put stuff out there and you don't control who else is seeing it. Because how does ChatGPT or any of those other modalities come to information and learn, even if there are false hallucinations out there? They're taking data, they're taking information. They're telling you that someone else has a claim of a similar type, and that means somebody else has put that out there. Now, that might be legitimate and fine because it came from a published decision, or it may have come from somebody who shouldn't be putting it out there in the first place. So it is really important, and this takes me all the way back to our first one, competence. If you don't know what you're doing and you don't know how to use the tool and you use the wrong one, not only are you not competently representing your client, or you're not competently handling the matter that's been placed in trust to you by whatever the parties have, however the parties have selected you, but you're also breaching your obligations of confidentiality. And so that is really incredibly important, and something that can get people, I think, in a host of trouble in addition to violating any of these other rules. And the last thing I will say is, while I noted at the outset that AAA, for example, has focused guidelines and rules addressed to arbitrators and use of AI, the New York courts and the New York professional responsibilities generally are focused on them more as practicing lawyers, as advocates. I don't think they've yet caught up to focusing with us as DR professionals. I still think they analogize to us. I think we're responsible and beholden to them. I think at some point, the rest of the world, since it's so DR focused, will catch up to maybe having rules directly on point, just the way the AAA and ICDR has. But I think they all generally should guide us regardless. And there's a list of, hold on, bringing it home,
Yeah.
a bunch of source materials.
Well, I just want to add that ChatGPT told me that it insists upon having the last word.
I thought that's
okay.
just David.
On confidentiality, it admitted that using cloud-based or third-party AI tools may risk data leaks or breaches of confidentiality. Arbitrators have a duty to protect the privacy and confidentiality of the proceedings. Drop mic.
Thank you.
Thank you.
Do you know what that
first of all,
even means?
I want to thank the audience that came here tonight, awesome audience, and also the people in the virtual world. We had over 150 people tonight, which is great. And obviously thank our wonderful panel. Big round of applause for them. And for Peter Phillips and New York Law School. But guys, thank you. Our 9th annual. Look forward to seeing you guys next year. So thank you.